Good morning, everyone. Good afternoon. Just wanted to welcome you all to this webinar on the ISDS cases. And thank you, Matteo and Alice, for putting this together. On behalf of the Sabin Center, really welcome everyone. And I just wanted to mention that this event is part of the Sabin Center's network for peer review scholars on global climate litigation, which I'll put the link in here that you can take a look. And Matteo and Alice are rapporteurs for ISDS cases. I really appreciate them putting this together, and then I'll leave it to Matteo to lead us away.
Thanks, Maria Antonia. Good afternoon, everyone. Also from my side, it's a true pleasure to have this 1 hour, very intense webinar, which is, as the title would suggest, focusing on ISDS as related to the general phenomenon of climate change litigation. First of all, to give you a brief introduction in 1 minute, hopefully, before turning to the actual contents of this webinar, I want to stress that the general aim here of this webinar is to explain how foreign direct investment protection and ISDS, investor state dispute settlement regime, can provide a forum for what can be said as mostly, I would say, anti-regulatory climate change litigation. Of course, as long as it allows private companies to claim compensation for loss of profitability of their investments as affected by national measures that aim at pursuing environmental and climate protection. So that is going to be the topic essentially at the core of this webinar. In particular, we will, let's say, pursue 3 main objectives here. So first, we will try to highlight the interplay between the international investment law regime and the climate change regime, both internationally and nationally. This was also stressed recently by the same IPCC Working Group 3. This is, of course, a boiling topic at different latitudes in Europe recently, but also stretching outside the borders of Europe. And well, it is clear that investment protection is at odds with the need to divest and phase out carbon intensive activities. It is arguably being advocated also as an upshot of COP27. Secondly, this webinar will also pitch ISDS cases, more specifically in the more general trend of challenges being posed to national measures affecting investments that are sensitive for a climate change perspective. So as we will see, there are several ways in which host states' decisions pursuing climate change objectives can be put into question before ISDS tribunals. So we will try to chart the field here and understand which kind of measures nationally can trigger ISDS claims. And third, we will try to flesh out some of the mechanics of investor state dispute settlements, which might not be well known to everybody in this virtual room, also in order to even further explain how the system works and how the above mentioned interplay between investment law and the climate change regime unfolds. So to do that, we have a very distinguished panel of speakers. Before introducing the first speaker, I would just mention to you that any question during the webinar and before the Q&A session, which will follow at the end, can be posed in the Q&A function and might be answered live by the speakers. But of course, we would like to collect your inputs and questions for the final round of discussion. So without further ado, I think I can hand over to Kyla Tienara, who is an interdisciplinary social scientist, and well, she focuses on the intersection between environmental governance and the global economy. And she is Canada Research Chair in Economy and Environment and Assistant Professor in the School for Environmental Studies at the Department of Global Development Studies at Queen's University. So Kyla, of course, you can feel free to take it away and give us some upshots about the regulatory chill in the warming world. Please, Kyla, the screen is yours.
Thank you, Matteo, and thank you for the invitation to speak today. So we are looking at investment treaties. So just so that make sure we're all on the same page, these are treaties between 2 or more states that provide protection for investors from one party when they're operating in the territory of another party. I'm just going to go through some really quick basics about these treaties. First thing to note is that there is a lot of them. There are more than 2,500 currently in force. The vast majority of these are bilateral investment treaties, also called BITs, but there are also regional or preferential trade agreements that include investment chapters. And we do have one sectoral agreement that you may have heard of. It's been in the news quite a bit lately, called the Energy Charter Treaty, or ECT, that has 50 members, mostly from the EU. So most of these treaties give investors access to a process known as investor state dispute settlement, or ISDS. And in this process, investors can bring claims for monetary compensation if governments implement policies that have a negative impact on their investments. And then a panel of 3 arbitrators will decide whether the state has breached one or more of the vague provisions that are in these treaties. I'm not going to go through all the vague provisions. I will just note that one of the most problematic ones requires states to provide what is called fair and equitable treatment to investors. This has been interpreted quite broadly by some tribunals as meaning that states must meet the so-called legitimate expectations of investors. And just to give you an example in the context of fossil fuel projects, this could mean that because companies could argue that basically being given an exploration license creates a legitimate expectation that they will get a concession if a commercial deposit is discovered. Final point that I think is important to know about these treaties is that investors can claim compensation not just for the money that they invested prior to a government's change in policy, but also for so-called lost future profits. This requires a lot of speculation on the part of the tribunal. Again, particularly if we're talking about cases in the fossil fuel sector, where you have to guess what the price of oil is going to be over the next 20, 30 years. I wish everyone luck with that kind of thing in these days. All right, so just to give you like a quick concrete example of what this might look like in practice, we can take an example of a government mandated coal power phase out. So such a phase out might result in some coal plants being shuttered prior to the end of their economic life. That means loss of either sunk investment or some expected future profits. Research does indicate that when governments force or accelerate asset stranding in this way, businesses expect to be financially compensated. If there is no compensation offered, or if the investor believes that the compensation offered is insufficient, then investors that have access to ISDS may sue the government. And even in the absence of an actual case proceeding, the explicit or implicit threat of recourse to ISDS can enhance an investor's position in any negotiations with the state over compensation. And then in turn, the outcome of the litigation or any negotiations on compensation might affect future government decisions about how to address the climate emergency. It might, for example, dissuade them from taking further action that would result in investors making further claims. So just going off that example, we can distinguish 2 types of implications, broad implications of the investor state system for climate policy. One, a concern that is talked about quite a bit and was mentioned in the IPCC report that Matteo mentioned, is called regulatory chill. This is the idea that governments may delay action on climate change or make suboptimal policy choices in order to avoid ISDS. A second concern is that governments will proceed with climate measures, but investment treaties will then function to increase the amounts of compensation that investors will receive, which thereby increases the cost of the overall energy transition and reduces the amount of public funding that is available for green investments and climate adaptation and so forth. Just diving into those in a bit more detail, I attempted a few years ago to sort of distinguish a few different categories of regulatory chill. Most obvious and easy to study is when an investor actually threatens to launch an ISDS case. This usually occurs when legislation or some kind of policy change is in like the proposal stage. The intention of the threat is to stop the legislation from being passed or implemented. So just to throw out an example of an investor threat, just a few days ago, ConocoPhillips said that it would sue Australia if they impose a windfall tax on the gas industry. You might not think that's a climate policy, but I think it's relevant. We don't have evidence yet in that case of a chilling effect, but it's just an example of a threat. There are other instances where we can see a cause and effect relationship between a threat and a change in policy, although it is very difficult to study. Second type of regulatory chill is internalization chill. This is the idea that regulators take the possibility of ISDS claims into account when they are designing policies in the first place. And therefore, they may design policies that are suboptimal from a climate or environmental or health or whatever perspective. Again, this is difficult to study, but there has been some good research done that relies on interviews with policymakers. There is also anecdotal evidence from investment lawyers that work for states that they have noted that they are often called upon to review policies for potential investment treaty incompatibility. And then finally, there's what I call cross-border chill. This is the idea that in certain policy areas, we have many countries around the world that are all wanting to do pretty much the same thing. So if one country is sued over a policy, then other countries might hesitate to adopt that same policy. And the intention of the investor might very well be to induce this kind of chill. So an example here would be Philip Morris sued Uruguay and Australia over the plain packaging of cigarettes. Neither of those countries is a particularly large market for tobacco. And I think the intention here was to try to get other countries to look at those cases and say, well, we're not going to do that. And the company did lose those cases, but they did take a long time. And New Zealand, for example, did delay the introduction of plain packaging until they knew the outcome of the Australian case. Obviously, climate change, we do need a lot of policy in a lot of places to happen in a very short time frame. So cross-border chill is something I think to be worried about. So studying regulatory chill, I have said several times, it's very hard, but we do have some preliminary evidence that it may already be happening in the climate sphere, despite the fact that we don't have a lot of policy yet that actually directly impacts fossil fuel companies. So we have a case in France where there was a threat of ISDS from a company called Vermilion, and subsequently the country's oil and gas phase-out law was redrafted to allow existing permit holders to renew their permits. In Denmark, which is one of the two initiators of the Beyond Oil and Gas Alliance, they reportedly set the deadline for their oil and gas phase out at 2050 in order to avoid ISDS claims. Now, in both of these cases, I'm not saying that ISDS was definitely the only factor in these decisions, but it does seem to have played a role. And then as far as smoking guns go, the journalist Elizabeth Meager interviewed the climate minister of New Zealand and got him on the record saying that the country did not join the Beyond Oil and Gas Alliance as a full member because there was concern that a Paris-aligned phase-out would have sparked ISDS claims. So as I mentioned, in addition to regulatory chill, investment treaties are likely to make the energy transition more expensive for the public, either through payout of awards or because companies use the specter of arbitration in their negotiations with governments for compensation. So just two examples here, the Dutch phased out coal power and developed a mechanism to calculate compensation for investors, but the maximum compensation for two companies, RWE and Uniper, was considered insufficient. And so both of those companies launched arbitration claims. Then we have the German coal power phase out, which involved a negotiated compensation scheme. And that has been widely criticized as being overly generous. And it has been noted that in the contracts negotiated with the firms, there were explicit provisions that were intended to prevent ISDS cases. So, I mean, here there is a whole debate about whether fossil fuel investors should be compensated at all when negatively impacted by measures to address the climate emergency. I definitely have views on that, but my argument here is primarily that investment arbitration is not the correct forum to determine when and how compensation should be given, particularly in light of the tendency of tribunals to adopt methods like discounted cash flow in order to generate lost future profits awards, which is very speculative and results in very large awards. All right, so with my remaining time, I just want to flag some areas where I'm concerned about the potential for ISDS cases to arise in the future, as well as regulatory chill. So this is just from a project that I did a couple of years ago with Lorenzo Catula at the International Institute for Environment and Development. We developed a data set of 257 coal plants that very clearly involve foreign investment and also present a reasonable risk of asset stranding in a Paris-aligned world, meaning they would need to be retired early and they would lose significant value. We found that 75% of those plants were clearly covered by investment treaties that had access to ISDS. That's likely an underestimation, but still it's a lot. And in terms of the distribution, Europe and Southeast Asia emerged as sort of regional hotspots, but definitely the global South is likely to be exposed to bigger ISDS claims because coal plants are typically younger in those countries. And I just want to emphasize overall that my concerns about regulatory chill are especially in countries in the global South that cannot afford to pay big investor awards or even necessarily to participate in arbitration. I mentioned previously that Uruguay was sued by Philip Morris. the country's legal fees were actually paid by Michael Bloomberg's philanthropic foundation. Without that support, the country might have actually abandoned its legislation. So in addition to coal plants, there's an increasing acknowledgement that we need to keep fossil fuel reserves in the ground. So in a study published in Science in May with colleagues at Boston University, I looked at the projects that would need to be canceled if we followed a 1.5 degree pathway. This was based on the IEA, International Energy Agency's net zero emissions by 2050 report and more research. So basically this suggested that at least 19% of the world's oil and gas developments that need to be canceled are protected by investment treaties. Again, that's probably an underestimate. And we tried to estimate what kind of price tag could be associated with this. And we came up with an upper liability estimate of 340 billion at a high oil price. And that's more than the total level of public climate finance globally in 2020. And reminder, this is just oil and gas. So if we actually factored in coal mining and fossil fuel infrastructure like pipelines, then it would obviously be bigger. Again, the distribution of the risks around the world is particularly concerning. We can see a lot of the countries here in the darker red have very little capacity to deal with ISDS cases or to pay awards. And this is where my concern about ISDS making the transition more expensive is relevant. We don't want these countries that are very vulnerable to climate change spending money compensating fossil fuel companies when they should be investing in mitigation and adaptation. So these maps are from a forthcoming article in Climate Policy. So I think I'm probably out of time, so I want to wrap up, but I just want to say in closing that because I think probably people in the audience today work on climate litigation, I just want to say I hope you don't fall into the trap of believing that there might be something in this system that is worth salvaging. There's currently a lot of greenwashing coming out of the arbitration industry because they're concerned that their business model is under threat, especially because the climate movement appears to be on the brink of bringing down the Energy Charter Treaty, which is amazing. And the greenwashing takes the form of arguments that ISDS can be used by renewable energy companies to challenge governments that rescind subsidies or make other policy changes that are detrimental to green investment. There are many reasons I could give you for why I think that this is sort of a dangerous and misleading narrative that the fossil fuel industry would be very happy for you to believe, but I don't have time. So I'm just going to end with this note, which is that the investment treaty regime is an affront to democracy, and we should never embrace it, even if we believe that the outcomes of some cases might line up with our objectives. The ends will never justify the means. Foreign renewable energy investors should rely on courts, just as domestic renewable energy investors do. So thanks very much for listening. And if you're interested in that paper, there's a link there that gives paywall-free access. I can also throw that in the chat. Thanks.
Thanks a lot, Kyra. Actually, ahead of schedule. So I think it was exactly the kind of bird's eye view we wanted to have on the most boiling points when it comes to the clash that is increasingly unfolding between the two systems. So I guess that will spark some discussion later on. So thank you, Kyra. And with this, I think I can pass the ball right away to Kate Hyam and Corey Silverman-Ratti. So that Corey and Kate in order. Kate first is Policy Fellow at Grantham Research Institute at LSE, where she coordinates the one and only Climate Change Laws of the World project. As you know, Corey is Climate Law Fellow at the Sabin Center for Climate Change Law at Columbia Law School, of course. And I'm very happy to have them both today here to present actually joint effort on mapping what could be called as climate-related ISDS cases, meaning cases that somehow, perhaps not necessarily at their core, have to do with measures that have been taken by national states for the purposes of climate protection, or in any event, are relevant for the purposes of the dynamics that Kyra has just brilliantly explained. So again, without further ado, since we are perfectly on schedule, I will pass the screen to Kate and Corey for 10 minutes.
Great, thank you so much, Matteo. I will just share my screen. And as Matteo says, this paper that Corey and I will be presenting today is really a joint effort with Matteo and also our colleague Joanna Setzer, who I think may be listening in. So Matteo and Joanna, we hope we'll do it justice. What we're going to talk about is, first, I will sort of introduce why we wanted to understand ISDS claims as climate change litigation and why they differ from other climate claims. Then I'm going to talk at a very high level about the number of cases that we found when we applied the several criteria that we derived from that initial definition. Corey is then going to talk about how we subdivided the cases once we had identified the ones we thought were climate relevant and how we're trying to sort of understand them in different categories. And then finally, I'll come back to talk a bit about key takeaways. So this first question of why we wanted to understand ISDS claims as climate change litigation, well, I think Kyla has really laid out the sort of rationale for doing that extremely well. There is a clear sense that ISDS cases might have a significant impact on climate governance. But in many ways, they don't fit our conventional definitions of what we normally understand as climate litigation. And I've put here on the slide the definition from Markle and Rule, which is very similar to the definition used by the Sabin Center for determining whether or not cases are should be considered climate change litigation. And typically they have to involve climate change as a material issue of science or law. And that's been the kind of understanding that we've had. And most climate relevant ISDS cases don't necessarily fit with this definition very easily at first glance. So typically in most of the climate relevant cases that we've looked at, climate objectives are generally sidelined. They don't appear in, certainly not in the claims by investors and actually not that significantly in claims by states or in defenses by states, at least to date. And to our knowledge, there isn't a single one of these climate relevant ISDS cases that actually focuses on climate science. Also, although climate policy is at the core of many of these cases, they're not typically concerned with the legal validity of mitigation or adaptation efforts, which is, I think, what we would normally expect from a case about climate law or policy. But arbitral tribunals typically take domestic law as a matter of fact in the cases. And so the way that we've chosen to try and understand this is when climate governance and policy and its impact on specific types of assets that are obviously climate relevant, I mean, most obviously energy assets, but actually also other kinds of assets in sort of land use sectors and so on. When those are the fact pattern that is sort of at the core of the case, we think it can be understood as a climate relevant ISDS case. So just to take a really quick example, Kyla mentioned that in 2021, two companies sued the Netherlands following their introduction of a coal ban that was introduced in 2019 and which has been explicitly linked in official documents to the outcome of the Agenda Foundation case. And so we would kind of classify the climate policy developments here as the reason that this case relates to climate, these two cases relate to climate law. An interesting fact that we don't get into in the paper is that following the arbitral claims by RWE and Uniper in May 2021, the Dutch government actually also sued the German court, before the German courts and brought anti-arbitration proceedings, basically arguing that the arbitration claims shouldn't apply. We haven't classified those as climate change litigation, but I think that's kind of an interesting question about whether or not they are and at what point in the chain this would stop. So drawing on this sort of idea that this factual pattern justifies us as thinking about these cases as climate litigation cases, we applied two assessment criteria to the body of investor-state dispute arbitrations that we have sort of knowledge about, because one feature of this system is that it's very opaque and not all the documents are public. But we looked at the kind of investments that are protected by the investor-state the international investment agreements, and then also the kinds of measures adopted by host states. And looking at those two assessment criteria, we found at least 65 cases against 10 countries that we think count as climate-related investor-state dispute settlement cases. If you see this slide, and I'll just hand over to Corey in a second, you can see that these, a lot of these were filed in sort of 2014 and 2015 and concern changes that European states were making to renewable energy policy. But we are seeing a sort of slight upturn potentially starting again in 2020 and 2021. And these, we would say, are more likely to continue growing. Those are cases that concern measures to phase out oil and gas in particular. So I'll hand over to Corey now, and Corey, let me know when you want me to change the slide.
Thank you very much, Kate. Can everyone hear me? Cool. Yeah, so as Kate mentioned, we have two criteria that we're looking at in order to fit these cases into the broader category of climate litigation. And the first thing that we're looking at is the kind of investment. And for this definition, we drew from the general investment definition established in the International Center for Settlement of Investment Disputes Convention, which defines relevant instruments as a financial or asset contribution by the investor, a certain duration, a risk, and a contribution to the economic development of the host state. In order for this type of investment to be climate specific, we're looking at whether the investment involves the acquisition of companies, direct investment, the creation of subsidiary companies, or the purchase of existing production facilities, either in the energy sector or in another high GHG emitting sector. You can go to the next slide, please. So we categorize the types of measures that governments take, and therefore the types of claims that we're looking at, into two broad overall categories. The first category consists of claims for compensation following the introduction of climate justified policy measures, which reduce the value of existing investments. And we call these stranded asset claims. Within this broad category, we define two subcategories. The first covers measures of general application, which includes bans, limits, or moratoria on high emitting activities. For example, investors may claim that a government policy, like a climate justified coal phase out, damages the investment security of a company in that country by contributing their legitimate expectations. And the RWE and Uniper cases that both Kate and Kyla mentioned are good examples of these types of cases. The second subcategory covers environmental permitting measures or decisions made by governments regarding intangible assets such as concessions, licenses, and permits. In these cases, investors may bring claims for compensation on the argument that they have invested considerable time and money in the permitting process, often at the behest of governments, and yet suffered losses when these processes ultimately do not result in the granting of a license or permit. The Echo Oro case is an example that I listed here. It can provide an illustrative example of these types of cases. In that case, Echo Oro entered into a concession contract with Colombian authorities to conduct mining activities. Now, despite the Colombian government's signals of support for the mining project, including a promising an exemption to a ban on mining in the area, the project was abandoned following a judgment from the Colombian Constitutional Court that struck down the legal provisions allowing for the exemption based in part on climate grounds. The company initiated arbitral proceedings shortly after the issuance of the judgment under a bilateral free trade agreement between Canada and Colombia. And despite significant dissent, the tribunal found that Colombia's conduct in the negotiations had breached the minimum standard of treatment required under the agreement through an arbitrary frustration of Echo Oro's legitimate expectations in the case. All right, so that's the first broad category. The second broad category of measures concerns the rollback or amendment of legislation or policy originally intended and introduced to meet states' climate goals. These claims are so far predominantly filed by renewable energy investors against governments after the government has changed its climate policy in a way that negatively affects the renewable energy investment. Most of these cases concern changes to policies or schemes introduced by European governments to support investment in renewable energy generation in order to meet EU-level climate targets. Now, one example that we can pull out here is PV investors versus Spain, in which a group of European investors filed a claim for compensation arising out of a series of energy reforms undertaken by the Spanish government affecting the renewable sector. And this resulted in a permanent court of arbitration award to the investors of 99.8 million. It's important to note that although we titled the second category the rollback of climate legislation, the measures do not necessarily form bad climate policy. And Kyla's point in her presentation is well taken. For instance, changes to renewable energy incentives schemes could be intended to make them more fiscally responsible, thus ensuring their longevity rather than justified as a way to weaken climate policy. And then a further point here is that both broad categories of claims can stifle good climate policy, just in different ways. Stranded asset claims against measures of general application can incentivize weaker and slower fossil fuel phase-outs, as Kyla laid out. And rollback of climate legislation claims may also have a chilling effect on the introduction of new subsidies and incentives, should states fear that they may be locked into the ongoing provision of such support, even where prevailing market conditions have changed and the subsidies are no longer necessary. Kate, we can go to the next slide. Long slide there. This here is a chart with a taxonomy of different kinds of measures that governments can take, and apologies for the small text, but it lays out the kind of, like in more detail, the kind of measure that a government can take, so more than just those three broad categories. It also lays out the standard of treatment invoked by investors in claims against these types of measures. And as a key for what we're talking about here, FET means fair and equitable treatment claims, MFN means most favored nations provisions, and NT means national treatment provisions. And then the third category here is how those different types of measures and the standard of treatment invoked fit into our categories of climate-related ISDS. Kate, you can go to the next slide, please.
Corey, I will ask you to wrap up, please.
Yeah. So we'll just wrap up quickly. Kate already mentioned the number of cases that have been filed. So you have those numbers, and we can go ahead to Kate for your last slide.
I think why don't we stop here? I think you've already given a kind of good sense of the key takeaways, and we don't want to eat into Alice's time, but we can get back into it in the discussion.
Okay, it's a wrap then. Thanks, Kate and Corey. I think it gave quite a lot of justice to our work. So no concerns from my side, but again, I would be happy to have some discussion afterwards also on this categorization, which of course, hopefully fleshed out the most relevant issues and also pitched even further the issue of material issue of climate change before ISDS courts, or tribunals actually. So with this, I can very briefly turn to Alice Astore. So Alice is Junior Associate at Legans, Avvocati Associati, and she holds an advanced LLM in International Dispute Settlement and Arbitration. And also, as Maria Antonia mentioned, she is also involved in the global network of peer reviewers on climate change litigation as far as ISDS is concerned. So without further ado, I will hand over the screen to Alice, who will zoom in on at least two examples of the broader categorization that Kate and Corey just explained. So Alice, the screen is yours for 10 minutes. And yes.
Yeah, you see, I'm gonna just try to start the presentation.
It goes.
Yeah. So, okay. Thank you, Matteo. I'm gonna try to be super quick, but in 10 minutes, it's gonna be hard to zoom in on climate-related ISDS cases. So probably it's gonna be just a scratch of the surface. But I followed actually this distinction that we just mentioned, Kat and Corey, about stranded asset claims and rollback of climate legislation claims. I'll present just briefly these two cases, which are both exit cases, and they're based on Energy Charter Treaty. I think it's really contentious right now, but I'll try to not be, I plan to be impartial. So I decided Rock Hopper, first of all, because it's super recent. I mean, I think the award was rendered to public not even 2 weeks ago. And bear with me, they're both Italian cases, and I think it was just yeah, by accident, but eventually I just like find amusing that I'm Italian and I'm speaking about just Italian cases. But just to give you a brief factual background, we have a rock hopper. It's actually, everything started with Mediterranean Oil and Gas, MOG, in 2005, had been granted with an exploration permit for hydrocarbons in Ombrina Mare. It was located at 6 miles from the country Adriatic coast, and is Abruzzo, it's an Italian region. And in 2014, Rockhopper acquired MOG and continued with the application process. So it's interesting because actually, as already mentioned by Kylie, we have in 2015 an environmental approval, and Rockhopper formally started this concession process. The point is that we had a host of projects in Italy, especially in Abruzzo region, and pressure from regional governments, but so activists, they were just like doing a lot of pressure, and eventually the government just changes kind of a law, it amended the law, and it's not no more possible to have oil drilling process at 6 miles, but it has to be at 12 miles. As a consequence, Rockhopper saw its application being rejected. And in 2017, he filed an ECT claim against Italy requesting full reparation. I don't know if we're going to have time, I think, touch upon a bit before in the first presentation about full reparation and also compensation. I think it's really interesting in these cases because probably it's linked also to the chilling effect, because we are talking about a huge amount. It's not just the real damages, but also the full reparation is intended in customer international law. But probably we can follow this theme in a discussion. So these cases, the claimant advises its case on liability based on 3 different strands of liability that are impairment, fair and equitable treatment, and unlawful expropriation. I'm gonna focus only on the last one, even though because technically because the tribunal just focused on this point and probably just dismissed the other 2 just because really it's just a spoiler, but yeah, eventually it was an unlawful expropriation according to the tribunal. And it's interesting because, as I said, we just have an environmental permission, but not a real concession. So what is interesting in this case, it's actually that the tribunal found that in 1994, the Italian decree, we have an Italian decree that actually required the production concession to be granted. And therefore, what they noticed is that actually therefore, Rockhopper had the right to be granted the production. And that's the main point. That's why we're talking about expropriation. When we're talking about expropriation in international law, we're talking about a general protection standard for investors that are embedded in several, almost every, I think, bilateral, multilateral, regional investment treaties. And you can differentiate between indirect or direct. I'm not going to go far in this distinction, but what is really interesting is that even just the fact that you have the right to be granted the production concession might lead you to have an unlawful expropriation. Italy in this case also invoked its policy powers to justify its actions, also because it was quite blatant that we had a public purpose. And as I said, also the tribunal actually tried to specify that when we're talking about expropriation, and even in the specific provision in ECT, we're not talking about something that is per se unlawful. Under customary international law, when you're talking about expropriation, it's actually lawful, but if it actually meets definite requirements that, as I said before, it's going to be a purpose which is in the public interest, and also mainly that's the main point, it has to be accompanied by payment of proper, adequate and effective compensation, which was not the case in this stance. And now just to talk about a similar case, I'm saying similar just because it's kind of giving the same kind of features. I'm not touching everything because as I said, it's gonna kind of like give, I don't know, it's gonna be hard to just like wrap up everything in 5 minutes, but I think it's interesting when you're talking about climate-related ISDS cases to know that it actually was clearly explained. You always gonna have some issues about fair and equitable treatment or also expropriation. And in this case, we're talking about Silver Ridge Power versus Italy again. And just to give you some facts about the case, Silver was a company incorporated in the Netherlands, and it owned and controlled an Italian subsidiary. And this subsidiary actually concluded an agreement, the GSE conventions, with the Italian regulator that it was Gestori di Servizi Energetici. And the main core of these conventions was that actually the plants, these 25 photovoltaic plants, would benefited from feed-in tariffs at a specified rate for 20 years. So the problem here is that, as I said, it is the rollback climate legislation claim, and therefore we can see that Italy progressively reduced these FIT incentives. So we have an incentive for renewable energy, but at the same time, during the course of the years, Italy tried to change the legal framework in somehow, or it just have these series of decrees that affected we have a decrease of the 8%, I think, about all the incentive that it could have been for the photovoltaic plants. And the result was the Silver Ridge challenged the adoption of this decrease. And again, we have a claim relating to expropriation and also VAT standard. So I'm going to focus this time on the fair and equitable treatment. ECT provides in the relevant part the main wording that you can find actually in several investment agreements. The main point is that this fair and equitable treatment standard protects foreign investors from fundamental or radical modifications. Now, the arbitral tribunals tend to interpret this standard quite broadly. So it's even hard to give you a definition, a proper definition of the standard, because sometimes it's broadly, sometimes it's more strict. But the main core that you can also witness in the recent European cases is that they try to find a balance between the two main, I think, views and principles. If on one side you have the investor, the interest of the investor to have a stable and transparent legal framework, and also is related to what has been already said about legitimate expectations. On the other side, you have the host state sovereignty and also what is intended as the right to regulate. So arbitral tribunals have always tried to resolve this kind of balance, to strike the balance between these two different principles. And I just briefly put here some of the main dicta. And as you can see, you have this kind of, they're striving to find this balance. They're talking about the absence of a specific commitment to the investor. And also, it's kind of impossible to say that for an investor that is actually conducting this kind of projects in the energy sector, they are super specific, they're super technical, to not understand that actually for a long-term investment is not going to be possible, that nothing will change. The legal framework would not go on changing. And I think the main takeaways will be that the host state is not required to freeze the legal framework. It's kind of impossible to imagine an investor that is not going to expect that circumstances prevailing in the time of the investment are going to remain stable and unchanged. And that also, when we're talking about fair and equitable treatment, we're talking about fairness, but it can't be intended as immutability. And therefore, the outcome of this case is actually the majority of the tribunal understand and acknowledge that actually Italy has given specific commitments. So we have a specific incentive scheme, but at the same time, the tribunal, the majority actually, say that Italy had not committed itself to leave this legal framework completely same frozen for 20 years. And therefore, they thought that actually the investor, a circumspect investor, must be prepared for this type of modifications, and therefore they didn't find Italy in breach in this peculiar case. With this, I think I finished. Yeah, thank you.
Yeah, perfectly on schedule. And thanks, Alice, for this, again, rundown of at least two major cases related to the broader categorization that, again, in this yet unpublished paper, Kate, Joanna, who is also in the virtual room, I see, also for the Q&A function, and Corey, have tried to do. I think it gave quite some headlights about at least the most important points of discussion before ISDS tribunals, and also to kind of, again, zoom in on what is the approach and rationale followed by ISDS tribunals. By the way, it is quite striking that I think in the Rockhopper case, the decision was taken by unanimity, which basically means that even the arbitrator appointed by Italy basically agreed with the other two, which is yet a bit uncommon, but nonetheless would be meaningful in terms of understanding even more how tribunals tend to handle these cases. So with this, I will just leave the screen to our last speaker. So circling back to Maria Antonia very briefly. So Maria Antonia will share with us some thoughts on the ongoing paper. So we're still work in progress here in this webinar, which is going to zoom in as well on the case that was already invoked in this room. So namely the Eco-Oro case, which made quite a lot of noise out there, given its factual background and also given its outcome ultimately. So I don't want to borrow any further time, so I will just hand over to Maria Antonia briefly for 5 minutes before we open up the floor for a bit of discussion. So thanks, Maria Antonia.
Thank you so much, Matteo. And I really don't even need 5 minutes, but I just wanted to, Corey already mentioned briefly this case about Eco-Oro and the government of Colombia, which I have written this paper with Lise Johnson and Michael Berger, and we've been analyzing, basically going through this case for the past year, because it raises so many questions in terms of climate policies and, within obviously the ISDS framework, but also in terms of climate policies in general. And the paper will likely be out, hopefully by the end of the year. So we will obviously share it widely. But I think there are a couple of questions that it raises that I wanted to bring up here, and maybe, bring this back to some of the speakers too as questions in terms of getting your thoughts on what that means for ISDS cases in general. One of the things that we consider in this paper is sort of how the award that the tribunal has granted suggests that investors can bring successful legal challenges premised on policy inaction or vacillation, even when lobbying and litigation threats contributed to that inaction or vacillation. So, I think the main problem here is that the Colombian government has taken so long to actually put in place the legislative measures to protect the Paramos ecosystem, even though it was established in the Constitution for a long time that it was supposed to do that. Which is, I should say, a common problem within global South countries in general, right? They have sometimes these amazing provisions, but it takes a lot of time for them to actually be able to implement them for, multiple reasons that we don't need to go into. But then that brings the opportunity for companies like Eco-Oro to actually, use that as an excuse of the stranded assets that that they're losing. So, when, that regulation eventually took place and had consequences for the potential investment that they would have, which I should say did not have an environmental impact assessment yet, but still, the tribunal said that they that they were entitled to some restitution for the investments that they made. So, you know, I think, you know, considering that and applying that to the climate context in general for climate policies, I think the decision there allows fossil fuel companies, which obviously have for long obfuscated the basic lessons of climate science and resisted regulation, to claim compensation for the pre-regulation value of their investments when governments do eventually take action. So, you know, so they then can bring, they can stall or shift the cost of action on climate change through even the threat of bringing ISDS claims. So I mean, maybe I'll just stop there and pose this sort of a question to all of you. It's something that we're exploring in the article, and, you know, hopefully you read that and share your thoughts, because I think it really brings questions that are much larger in terms of climate policies in general. And I think that applies especially to countries in the global South. So I'll stop here.
Thanks a lot, Maria Antonia, for a bit showing us some major points as a heads up about this, I think, very, very topical paper here, because EcoRo, as you said, raises quite a lot of questions, even all the more because it's related and targeting, as you said, a country that is, of course, located in the global South, and which, of course, a little bit fuels all sorts of, let's say, inherent characteristics or dangerous characteristics from a climate change perspective of ISDS, as Kyla has mentioned at the very beginning of this webinar. So with this, I would just open the floor for a bit of discussion and the question. I see there is a question already from Joanna, of course, so perhaps I can place it back to the audience a bit, and specifically to Kyla. And so basically, I think Joanna's point is related to the last point one of the last points you made, Kyla, about the potential greenwashing. That, of course, well, investors can make, basically saying, look, ISDS can be important in terms of protecting investment in low carbon technologies. So if you could elaborate a bit on that, how do you think this strategy could work out, and if there is evidence of this kind of, let's say, dynamic popping up, so we can perhaps take the discussion away from here, because I think it is a very important point you made, and I think it's important also for the audience to properly understand exactly, yeah, let's say, the hidden context behind the whole ISDS system. So Kyla, if you want to elaborate on that, and then we can spark a discussion.
For sure. Just before I go to that, I just want to mention that I think that point that Maria made about the obstruction by the fossil fuel industry is really critical, and I think means that nobody should ever think that they have legitimate expectations to business as usual. So, but my question is whether states are actually going to raise those kind of issues in their defenses, or whether, for, you know, political strategic reasons, they don't want to admit the fact they've been obstructed by fossil fuel industry. But definitely, I'm very much looking forward to reading that paper. On the renewable energy stuff, so there's two aspects to this. There's the first, the question of, you know, whether the treaty system can be useful at all for promoting renewable energy and green investments. I have written a paper on that a couple of years ago in Global Governance, specifically about the Energy Charter Treaty, and I sort of go through the reasons why I don't think it is a useful framework. The first one is most obvious, is that we haven't talked about it in this seminar, but the original purpose of these treaties was to facilitate flows of investment, particularly to the global South, because those countries were trying to attract investment. But there's so much work done on that topic, and nobody can actually definitively prove that they function in this way. So there's really weak evidence that they do what they're supposed to do. So the only purported benefit that they could have is not proven. And it's not proven for any type of investment, and not specifically proven to be relevant in renewable energy investment. Another important thing to note is that most renewable energy investment, at least at the moment, is domestic, so it's not protected. So in all those cases in Spain, you only have the foreign investors able to use this mechanism. The domestic investors have to only rely on local courts, and that discrepancy is something that people find inappropriate. Why should foreign investors be treated better than domestic ones? In terms of you know, whether or not it could actually create some kind of regulatory chill, so prevent governments from scaling back. It depends on the type of thing we're talking about, but a lot, I think with subsidies, it's one issue, but renewable energy is now getting to the point where it's so cheap that they're not going to need subsidies anymore. We should be more concerned about whether fossil fuel companies are going to start threatening cases about fossil fuel subsidies being rolled back. In terms of other kinds of opposition, like local opposition to wind and things, in the Windstream case here in Ontario, where I live, a lot of that opposition is about the way that renewable energy projects are rolled out, and could be addressed in better ways than just providing investment protection. But also they're often done the decisions are made at a local or provincial level, whereas it's only the federal government that's responsible under investment treaties. So regulatory chill, I think, is less likely to have any impact on stopping local level governments from making bad decisions about renewable energy. All that aside, I haven't documented thoroughly like the greenwashing, but I do mention some instances in that 2018 paper about how authors that talk about arbitration in positive ways are increasingly mentioning that this sort of green aspect is important. And if you look at the debates around the Energy Charter Treaty, you will see a lot of the defense has turned to the green defense, I think, because they see the threat is coming from the climate movement. And so the response is very much, no, you actually need to keep this system. It's good for the transition. So, but it would be great to see a paper that thoroughly sort of tracks that.
Thanks, Kyla. I think this addressed quite thoroughly. At this point, I would like also to report another question that perhaps it can be directed to everyone, to Kyla primarily, but again, it talks about greenwashing, but I can also direct it to Alice as well, specifically on the ECT, of course, so the Energy Charter Treaty, which is one of the very few multilateral investment treaties. And it's on the, a bit on the edge now, especially from the European perspective. So the question is whether the ECT has been used in favor of green energy investor, and whether it will still be used for a long time due to sunset clauses. This is getting a little bit technical. So perhaps also if Kyla wants to share 30 seconds of thoughts on the ECT and the sunset clause, and I can hand over to Alice and Kate and Corey for a couple of thoughts, but to be very brief, because also I see the time is also creeping upon us. So Kyla, a brief thought on the ECT and the sunset clause, but perhaps I can hand it over to Alice as well.
Yeah, I'm not an expert on sunset clauses, but I think that the general sort of feeling is that it can be neutralized through an inter-se agreement between the countries that leave, in the same way that intra-EU BITs have been canceled. So there's arguments about whether or not that will actually work, but that is I think it's a better route to take than to continue with the treaty that's not fit for purpose.
Thanks, Kyla. Perhaps Alice, if you have some follow-up thoughts on the sunset clause, on the future of the ECT as well, what this would mean for let's say for climate policy more generally. Of course, this is an ongoing discussion because we have news being every day. But
yeah, you were actually saying that actually we are kind of not lawyers or still jurists, but we have to be updated on the newspaper to know what is going on with the ECT. I mean, on a daily basis, we see states that are just withdrawing, and probably, as you said, it's actually sunset clause is 20 years. So it's not even a short one, it's a long one. And I think we're still gonna have cases that are just spurring for the ECT. It's true that actually it has been introduced, but as I say, Kyla, I mean, ISDS, they were thought as a way to spur investment in the global south, and eventually probably they're going to be the ones that actually it's going to be detrimental for them, probably. We don't know, but it's still the system. I mean, everything can be detrimental if you have the actors that are not using them properly. And perhaps we're going to have some clauses that are going to change. We have tons of negotiations. We have, I think the next one is going to be the 22nd of November about the ECT. And still we haven't reached an agreement on what would be a real kind of modification of this treaty that is not making it kind of a horrible tool for energy and renewable energy, and also for the transition, and I think we have to wait for that. I don't think it has started as an awful thing, but at the same time now it's using as a tool to just, I don't know, because there are a lot of cases actually that are just saying that it's not possible, as Kyla said, that you could not expect that it's going to change something, and legitimate expectation, now they're finding a new kind of definition. And perhaps we have a recent case, always against Italy, sorry for that, but a recent case, it was saying that actually the fair and equitable treatment, for instance, has a high threshold, and therefore we need a subversion of the legal framework, which it's kind of hard to prove at the same time. So probably it's going to be a change in this, and how the arbitrators are gonna also decide. Probably it's gonna be different. I'm kind of curious though, when Kylie said that it's better national courts. I think it's just like my side, because I always, I like the system. I like at least the theme and also the purpose behind the system, but at the same time, I can't see this kind of cases treated in a local court. I'm just imagining it in Italy. I don't think judges are equipped properly right now. Probably it's going to change, but right now I don't think they're equipped properly to decide on this kind of matter.
Thanks, Alice, for sharing this. Of course, this would take us very far, because there are a lot of technical issues that, of course, are peculiar to the ISDS system that should be explored. There is one last point, perhaps, because we're already overshooting, about legitimate expectations, more particular, is Carolina asking this. So if the question is, there has been a lot of discussion on states arguing legitimate expectations against investors. So she's wondering if this came up in any of the cases that we have discussed. So I don't know who wants to take very briefly on this question before we wrap up. Perhaps Alice or Corey, Kate, who haven't spoken yet. Feel free to jump in on this.
Maybe I can jump in on this. I think this is a really interesting question, and Kyla's already sort of alluded to the fact that there might be reasons why states are a bit reluctant to say, well, you should have known that we would never have been able to carry out this policy that we told you that we were going to carry out. But I think in the case of fossil fuel investments, if we sort of zoom in on that, then the question of kind of due diligence arguments, like investors should have done their due diligence and realized that the direction of travel was that these assets would potentially become stranded assets. I think those are really strong arguments. And that's very clearly from some of the documentation around the Dutch cases. That's very clearly what the Dutch government will argue if they have to make arguments before the arbitral tribunal. They're going to say, well, these companies should have known, they should have known that we have the Paris Agreement, we have these ambitious targets. And I think it's quite a strong argument, particularly if we think about what is happening in terms of things like the Task Force for Climate-Related Financial Disclosure recommendations becoming mandatory in so many jurisdictions, really a big investor pressure on companies to understand transition risks, which has, been going on for many years now. So I do think that this is a kind of an interesting topic, basically, and one that could counter the regulatory chill, but of course you see more, we know that regulatory chill exists, and if states wait to see what happens in the Netherlands, as New Zealand did in the Philip Morris case, as Kyla was saying, that's going to put us way behind on our necessary policy schedule. So we do need an alternative solution to waiting for 5-10 years while these arguments play out.
Thanks, Kate. Anybody wants to follow up briefly on this point? I totally vouch anyway for what you just said about due diligence side of things, and also investors' obligation. This is quite one of the points that is getting ground also in the intellectual discussion, because this seems like a system that is definitely geared towards giving investors rights on legitimate expectation, right to their investment not being impaired, taken away, things like that. But I would say that this system also holds obligations for investors, and you mentioned due diligence as one of them, and this is where you can find some rebalancing. But this, I would say, is mostly in the hands of arbitrators, and this opens a whole kind of discussion about the actual, let's say, internal dimension of ISDS, so how our system works and what interest it pursues, which I think would deserve quite more than 1 hour discussion, I think. But so I'm wondering if anybody has a follow-up on this point, because otherwise we're already 6 minutes overshooting. So I would just wrap it up as such. Corey, Alice, Maria Antonia, anybody wants to give a final word on that?
Just wanted to thank everyone, but also remind you that there's going to be a quick survey that's going to show up. If you could please just respond, and it shouldn't take more than 2 minutes. Thank you, everyone of the participants, and for Matteo and Alice in organizing this as well. Appreciate it.
Yes, thanks for pointing this out, Maria Antonia. I hope this kind of brief and strict Friday afternoon or Monday, depending on where you're placed, webinar on ISDS was a little bit of, ISDS 101 as related to climate policy, but of course we can take it farther away. Of course, this is one of the strands of research that has been done under the global network of peer reviewers of climate change litigation. So it has been a pleasure for me, of course, to organize this together with Alice, who I do thank, and of course, thanking all the marvelous speakers we had today. So as you said, as you could see, there is a lot of also academic work being done on its way in the pipeline. So stay tuned on that. Of course, the recording will be up online soon, and hopefully we will again follow through on this webinar and shape it up even further, as of course a lot of things are happening in the ISDS world. So thank you, everybody. I will call it a wrap, and I wish you a very nice weekend ahead. Thanks again to everyone in this virtual room, participants and speakers, for participating today. So it's a wrap. Bye, everyone.